But we begin tonight with new reporting on the special counsel's investigation into Donald Trump's handling of classified documents that seem to undercut Trump's longstanding defense in the matter.
Just so you understand, I had every right to do it. I didn't make a secret of it. You know, the boxes were stationed outside of the White House. People were taking pictures of the GSA of the various people. I took the documents I'm allowed to. And by the way, they become automatically declassified when I took them.
Yeah, no. First, let me be clear. Classified documents don't just automatically become declassified because, you know, a president takes them to his vacation home once he leaves office. And now it appears there is further evidence showing that even Trump knew that to be the case. Multiple sources tell CNN that federal prosecutors have obtained an audio recording of a meeting held in the summer of 2021 where Trump talks about a classified document he held on to about a potential attack on Iran. CNN reports that the recording indicates Trump understood he retained classified material after leaving the White House, according to multiple sources familiar with the investigation. On the recording, Trump's comments suggest he would like to share the information, but he's aware of limitations on his ability post-presidency to declassify records, two of the sources said. That meeting, held at Trump's New Jersey Golf Club, was with two people working on an autobiography of Trump's former chief of staff, Mark Meadows. Those two people did not have security clearances that would have allowed them access to classified information. Sources tell CNN that special counsel Jack Smith is focusing on that meeting and described the recording as an important piece of evidence in a possible case against Trump. Joining me now is Glenn Kirshner, former federal prosecutor and MSNBC legal analyst, Hugo Lowell, political investigations reporter for The Guardian, and David Cay Johnston, who has reported on Trump for decades and is the author of The Big Cheat: How Donald Trump Fleeced America and Enriched Himself and His Family. I'm going to go to you first, Hugo, to tell me the latest of what you know about this reporting.
Yeah, look, we confirmed this shortly after the CNN report that in July 2021, Trump sits down for a meeting with ghostwriters of Mark Meadows' memoir and Margot Martin, this press aide. Trump has all of these conversations recorded because he doesn't trust the journalists or the other people on the other side of the table. Okay. But this is what seems to have bitten him in this instance. Because
just to be clear, this is at Bedminster. This is not at Mar-a-Lago. Right.
So in the summer months, Trump goes from Mar-a-Lago to Bedminster. He typically spends the summer in Bedminster.
Right.
And Bedminster is interesting because that was also where Tim Parlatore, the recently departed Trump lawyer, suggested, you know, they didn't want to do a search of Bedminster because they were worried about what they might find. Mm-hmm. But this conversation in particular is significant because, from what we understand it, Trump was talking about retaining a secret-level document. Secret-level documents are the kinds of things that the Justice Department prefers to charge in espionage cases. Top secret, it's very difficult to get clearance from the intelligence community to get those declassified for an indictment and for trial. Confidential documents might not be as compelling to a grand jury. A secret document, that's exactly where you want to be.
So it's in the middle between the top level of secrecy and the sort of mundane level of secrecy, so that is more appealing. How long has Jack Smith had this?
So we understand he has had this about several months, from around mid-March. The way it came into the special counsel's possession, we don't know. But we know that Margot Martin testified to the grand jury in March, and we also know that she had her laptop and devices imaged by prosecutors working for the special counsel. So when she went in, she was asked to talk about this recording, and multiple other witnesses were also asked to talk about this recording. And we also learned today that Trump was actually subpoenaed for this recording himself.
And Mark Milley has been interviewed because of this. Let me just read this a little bit. And this is the CNN reporting, and I know that The Guardian has also matched the reporting, but here it is. The meeting in which Trump discussed the Iran document with others happened shortly after the New Yorker published a story by Susan Glasser detailing how, in the final days of Trump's presidency, Milley instructed the Joint Chiefs of Staff to ensure Trump issued no illegal orders and that he be informed if there was any concern. The story infuriated Trump. Glasser reported that in the months following the election, Milley repeatedly argued against striking Iran and was concerned that Trump might set in motion a full-scale conflict that was not justified. Milley and others talked Trump out of taking such drastic action, according to the New Yorker story. And so I want to go to you really quickly, David Cay Johnston, because the story, as it plays out, is that Trump is bragging that Milley had a plan to attack Iran in these conversations. And then he starts waving around paper, and you can hear sort of paper rustling on these recordings, and says, if I could show you these documents, it would prove that Milley is not telling the truth when he says he had no such intention of planning an attack on Iran. So that is sort of the staging of all of this. Talk a little bit about Donald Trump. Is it plausible in your mind that the thing he's waving around is the real classified documents that he pinched from Mar-a-Lago, having pinched them from the White House, or that he's just, profiling, for trying to have swagger, but that it's not the documents?
Well, Joy, this would be classic Donald. Ooh, look what I have. And he's done this with photographs and other evidence to people over the years. In the case of General Milley, it's quite clear that General Milley would not be in favor of attacking Iran. But guess what? If the commander-in-chief says we want a battle plan, the Pentagon will cook you up a battle plan. That doesn't mean you're advocating it. It means you're following an order to present a plan. And understand that the Pentagon does war game exercises all the time. Sometimes they do these war game exercises with Hollywood directors and screenwriters. And frankly, I wouldn't be shocked, knowing some of the war games materials I've read, if the Pentagon had done things like imagined a war between Chile and Argentina as one of these exercises. So it's meaningless that he had a document that laid it out. But did he have a real document that he shouldn't have? Yeah, what we know of the tape, which no journalists or prosecutors outside the office have heard, what we know of the tape suggests very strongly that, yeah, he had the real deal there. And long ago, I said that Donald wouldn't know how to understand a lot of classified documents, but Donald knows value, and he knows what something is worth.
And that would be a motivation for having it. Let me play what Andrew Weissmann, former federal prosecutor, said earlier with my friend Nicole Wallace.
If this reporting is true, and I'm trying not to use hyperbole, this is game over. There's no way that he will not be charged. One, it's a tape recording. Even though the reporting is there are also witnesses, so there could be tape recording with witnesses. It involves not just possession of classified information, but dissemination of classified information. That puts it into a completely different ballpark when you're at the Department of Justice examining the seriousness of the violation and whether to bring charges. It is hard to see how, given all of the evidence that we've been talking about, that there will not be a conviction here.
Glenn Kirshner, former federal prosecutor, do you concur?
I do, and let me build on what Andrew said. I see this reporting as sort of an incriminating information twofer from a trial prosecutor's perspective. First of all, it may be further evidence that Donald Trump mishandled national defense information. Remember, that's one of the charges that served as the basis for the Mar-a-Lago search warrant. That falls under the Espionage Act. That ain't no small potatoes. So that is incriminating information, number one. But the other thing that Donald Trump does not realize and will never realize is it may feel good in the moment when he says this stuff to those faux news networks or at his campaign rallies or town halls, or he posts things on his social media platform saying, I can declassify things with my mind. They are automatically declassified when I take them from the White House. What a trial court prosecutor will do, Joy, is they will play that recording of Donald Trump for a jury. They will immediately follow it up with a recording of Donald Trump saying, I can't show you this because it is classified, even though I took it from the White House 6 months ago. This is evidentiary gold. This is the kind of thing that persuades a jury when you can prove the crimes with the defendant's own words in two conflicting audio recordings. And I have long said, Joy, and we've talked about this, these cases will try themselves once federal charges are brought. The problem is, and the sticking point is, they won't indict themselves. And we are still here waiting for a federal indictment.
Yeah, indeed. Hugo.
Well, I was just going to say, and Glenn touched on it, but we don't have evidence yet, or we may never get evidence that Trump disseminated these documents. I think that's important because Section 793 of the Espionage Act has 2 points. There is the dissemination part and there is retention. So far, we've only got up to retention, at least with respect to this recording, and it's not clear if that alone is sufficient to charge. If there is evidence that he was showing classified documents, then it really is game over.
And Glenn, follow up on that, because the question is taking the documents to Bedminster. We know there's some obstruction issues with refusing to give them back when they're asked for. This takes place before they then send documents back. We do know there have been conversations with staffers about, hey, how do the security cameras here work at Mar-a-Lago? So we see some obstruction issues. But if he then took those documents to Bedminster and didn't actually physically show it to someone, but sort of mimic doing it, does that get you close enough to dissemination?
The only person who can definitively answer that is a jury once they're presented with all the evidence. But I agree with Hugo's point. The Espionage Act, the mishandling of national defense information is probably less strong than the wrongfully removing government documents, which was one of the charges that served as the basis for the search warrant at Mar-a-Lago, and the obstruction of justice, Joy, which is a lay-down winner because after they were subpoenaed by the grand jury as part of a criminal investigation, Donald Trump unlawfully continued to conceal them. So, only a jury can answer that question. But you know what? If you have 2 blockbuster charges, including obstruction, which is a 20-year max, I would be okay with the special counsel deciding to forego bringing an espionage charge because you can only confine a man for but one life.